Good afternoon, everyone. My name is Ryan Lever. I'm the Deputy Dean Research of the School of Law here at the University of Queensland. And it's my distinct pleasure and privilege to welcome you on behalf of the Law School to this public lecture by my colleague Dylan Lino. I respectfully acknowledge the Turrbal and Jagera peoples as the traditional custodians of the land on which we meet. Many of us engage on this land in the pursuit of knowledge and the transfer of knowledge to others. The Turrbal and Jagera peoples have been doing this here since time immemorial. They have loved and nurtured this land and have performed here age-old ceremonies of celebration, initiation, and renewal. They have never ceded sovereignty over their country. I pay my respects to elders past and present, and I extend that respect to any Aboriginal or Torres Strait Islander person joining us today. This afternoon's lecture, which the Law School is very pleased to be co-hosting with the Academy of the Social Sciences in Australia, tackles an issue of great social, political and legal significance, namely the interface between Australia's constitution and Indigenous rights. The lecture will reflect on how to draw on Australia's constitutional traditions and practices to support campaigns for Indigenous rights, including major reallocations of political power to First Nations, rather than simply being obstacles to the proper recognition of Indigenous claims to land, culture, and sovereignty. This lecture also marks the beginning of a series of events organized by the Law School, the Law Matters series. The string of lectures and seminars will highlight important and impactful research from scholars within the school, as well as our collaborators and colleagues from academia and the legal profession. Taking its cue from today's lecture, the Law Matters series will tackle important topics in law and policy, including disability rights, the security of the cyberspace, deaths in custody, just to name a few. We invite our colleagues, as well as the wider community, to join us in a forum that unpacks impactful research and addresses legal issues of national and international significance. In 2022, Law Matters will involve a combination of in-person and online events open to all, so watch this space. Today's lecture is, of course, a special occasion, as it is also a Paul Bourke lecture. These lectures are presented annually by the recipients of the Paul Bourke Awards for Early Career Research, awarded by the Academy of the Social Sciences in Australia. Our speaker, Dr. Dylan Lino, received the award in 2020, recognizing his influential work in informing the debate on Indigenous constitutional recognition in Australia. I am delighted that we are joined today by Dr. Chris Hatherly, CEO of the Academy of the Social Sciences in Australia. I would invite him to say a few words about the Paul Bourke Award and the lectures. Chris.
Thank you very much, Ryan, and it's a pleasure to be here today. I would also like to acknowledge and pay my respect to the traditional custodians of this land and to all elders past and present, and to acknowledge any Indigenous people here with us this afternoon. It's wonderful to be here in person after endless webinars and Zoom sessions, to actually be able to travel, in my case from Canberra, to be at the first of these lectures that we've had in person in 3 years. The Paul Bourke Awards are the Academy's Early Career Research Award, and they're awarded each year to now 4 recipients across each of the Academy's 4 disciplinary groupings. The Paul Bourke Lecture is named in honour of the late Professor Paul Bourke, who was an eminent Australian historian with broad interests across many fields. He served in a range of different roles, as Foundation Professor of American Studies at Flinders University firstly, and later as Director of the Research School of Social Sciences at the ANU, and as Deputy Vice-Chancellor at the ANU as well. He was the Academy's President from 1993 to 1997, and during that time, among other things, he was heavily involved in setting up the National Academies Forum, which was the precursor to the Australian Council of Learned Academies today. Professor Bourke died unexpectedly and far too early in 1999. One of the many things that his colleagues and friends remembered him for was his passion and commitment for supporting early career colleagues and research students within his fields. And as such, it's fitting that in 2008, the Academy renamed its Early Career Award in honour of Professor Bourke as the Paul Bourke Award for Early Career Research. There have been many eminent recipients of this award since it was established in 1987, the original Early Career Research Award. Just from this university, the recipients include Professor Terry in 1994, along with Professor John Quiggin, Jason Mattingly, Thomas Suddendorf. A more recent UQ recipient, Associate Professor Melissa Day, has recently been elected chair of the emerging Shape Futures Early and Mid-Career Researcher Network that's being established jointly by the Academy of the Social Sciences and the Academy of Humanities. And there'll be more information about that being broadcast shortly. So any of your early career colleagues or any of you who would be interested in that kind of national network, look out. There's going to be some interesting things happening. Collectively, the recipients of the Paul Bourke Award represent Australia's best social science scholars. Many of them go on to become fellows of the Academy in their own right, and others serve in distinguished roles in other areas of public life. Having had the pleasure of working with today's speaker, Dylan, on several occasions, most recently as a member of the program committee for the Academy's annual symposium last year, I've got no doubt whatsoever that an impactful future is in store for him as well. Thank you very much.
And of course, as this lecture is such an important event in the life of the law school and such an important event for Dylan, we were also very keen to secure the best warm-up act possible. In our case, that is our Vice-Chancellor, so I give the floor now to Professor Debbie Terry.
Thank you, Ryan, for that generous introduction. Can I too acknowledge the traditional owners of the lands on which we meet here today. We honour their elders and their continuing cultural and spiritual connection to this land as we walk together on the path to reconciliation. I'd also obviously like to acknowledge Dr. Chris Hatherly, CEO of the Academy of Social Sciences in Australia, and I've seen you on the screen quite a few times in the last 2 or 3 years, Chris, so it's great to have you with us. Our guest lecturer this afternoon, Dr. Dylan Lino, and obviously UQ colleagues and alumni, distinguished guests, one and all. And it really is a privilege for me to be here this afternoon for the launch of this new Law Matters lecture series run by the university's T.C. Byrne School of Law. And as Ryan's already outlined, our sincere hope is that this lecture series will establish a reputation over time as an important forum for exploring the impact of the law on the functioning of a free, fair and just civil society, both here in Australia and more broadly. And I'm delighted that the very first lecture in the series is being staged in conjunction with the Academy of the Social Sciences in Australia, ASA, as a Paul Bourke lecture. And I think, as Chris has already mentioned, the late Paul Francis Bourke was a towering figure in the field of social sciences in Australia, and certainly as somebody who spent quite a lot of my career before I came to UQ in 1990 as a postdoc at ANU, I was certainly aware of his impact, and his impact broadly across the social sciences was really very, very significant. And I think it's very fitting that the Academy's Early Career Award is obviously named in his honour. Now, as we'll hear this afternoon, I think our emerging research leaders in the social sciences make an enormous contribution to Australia's intellectual fabric. As a society, our national debates are continually being enriched by the fresh perspectives and insights of our early career researchers, working across all of the social sciences. And as many of us know in this room, the social sciences, of course, have a vital role to play in responding to many of the great challenges of our time, whether that be dealing with the rapid pace of technological change, responding effectively to our future energy needs as the climate changes, or as we build a stronger, fairer and more just society for us all. And as I think we all do appreciate, the solutions to these big societal challenges will increasingly be found by adopting cross-disciplinary approaches that incorporate deep expertise from the social sciences. Now, when I had the great privilege of being president of the Academy a few years ago, I often drew attention to the critical role that our learned academies must play in these important national policy debates. Gone are the days when our academies can be and were indeed just focused almost entirely on membership issues. Who was going to be elected in for that next year, and big debates around new fellows, etc. Instead, what's happened over the last few years is the academies have become a strong voice, not only for the disciplines that we represent, but also for the impact that we can have collectively to help address the major issues facing Australian society. And the Australian Council of the Learned Academies is now sought after by many across government, by chief scientists and others, to really come together with advice around how do we deal with some of these intractable issues. And one of the very powerful ways I think that the academies do have impact is by celebrating the success of our emerging researchers and the contribution that they make to informing our national discourse and, of course, helping to guide policy development. So on that note, it gives me great pleasure to be here today to introduce Dr. Dylan Lino to deliver his Paul Bourke lecture. Dylan is a senior lecturer and an exceptional early career researcher based in UQ's TC Byrne School of Law. His research is focused on the history and politics of Australian law, with a particular focus on the intersection of colonialism, constitutional law, and the rights and status of Aboriginal and Torres Strait Islander people. Dylan holds a Bachelor of Arts and a Bachelor of Laws with honours from UNSW, a Master of Laws from Harvard University, and a PhD from the University of Melbourne. He's the recipient of multiple awards, including the prestigious Qantas Fellowship and the 2018 Wenderbourne Byrne Prize for the best article published in the Modern Law Review. He was awarded the Holt Prize in 2017 for his book, Constitutional Recognition, First Peoples and the Australian Settler State. In his relatively short academic career, Dylan has already had a very big impact. His co-authored submissions to government inquiries have been influential in informing the discussion, and the really important discussion, around the constitutional recognition of Aboriginal and Torres Strait Islander people in our law and in our society. And I've no doubt we'll be hearing much more from Dylan on this most important topic in the years and decades ahead. But it's now my great privilege to invite Dr. Dylan Lino to the lectern to deliver his Paul Bourke lecture on the question of, are Indigenous rights inconsistent with Australian political traditions? Please join me in making him feel welcome.
I want to start by acknowledging the Yagara and Turrbal peoples on whose lands the University of Queensland, this St Lucia campus, has been built. I want to acknowledge that those lands were taken without consent or compensation, and that those lands were taken without sovereignty ever being ceded. I want to acknowledge the elders and the families of the Yagara and Turrbal peoples and express my solidarity with their ongoing struggles for justice. It's a great honour and I'm extremely humbled to be introduced by the Vice-Chancellor today, and very humbled by her generous, overly generous remarks. I should also round out my professions of humility and honour with one for the Academy, and for me, I guess being awarded this great honour, the Paul Bourke Award. So I want to thank the Academy for their support, and especially Chris for coming up here today. I want to give a big thanks to Rob Mullins and Rebecca Wallace in the law school, Emma Pryor, Hayley McLeod and Ellie Price in the Faculty of Business, Economics and Law. All of them have done a lot of work getting this event organised here today. So thanks to all of them. And thanks to everyone who's made the time to come out today, especially given that you actually had to turn up in person rather than just zoom in. I'm a non-Indigenous person whose ancestors came to Australia from England, New Zealand and India. Some in the late 19th century, most after the Second World War. I grew up on the stolen lands of the Nyangbull and Arakwal peoples of the Bundjalung Nation, which is country down around Byron Bay, Lennox Head and Ballina. As with the rest of Australia, these are places with deep and ongoing histories of Aboriginal occupation to this day, as well as histories of incredible violence and dispossession that began with the arrival of settlers in that area around the 1840s. I now live on stolen Yuggera and Turrbal lands, which have their own histories of deep and ongoing Aboriginal occupation, settler invasion, violence and dispossession, Aboriginal resistance and resilience. In an experience that continues to be all too common, I think, among settler Australians, I don't remember knowing much growing up about the Aboriginal history of this country. My deeper education into that history really properly began, I would say, when I started studying law at UNSW in the mid-2000s, around the time of the Howard government's abolition of the Aboriginal and Torres Strait Islander Commission and its subsequent intervention into the Aboriginal communities of the Northern Territory. For me, it was around this time that I guess a more general concern for social justice began to turn in a much more focused way towards the relationship between Aboriginal and Torres Strait Islander peoples and the Australian state. It was then that I first got to meet, study and work with the person who's had the biggest intellectual impact on my career so far, and I think it's safe to say probably into the future as well. And that person is who I think the incomparably brilliant Professor Megan Davis, who is a long-time mentor of mine, colleague, friend, inspiration. And I know that she would be here. She had registered, but she's in New York at the moment doing stuff at the UN. So I'll forgive her. It's been the greatest privilege of my professional life to work with Megan and many others over the past decade and more in the pursuit of constitutional change that recognises the rightful place of Aboriginal and Torres Strait Islander peoples in this country. I'm completely in awe of Megan's unwavering dedication to and sacrifice for that struggle, which she's lived and breathed in her every waking moment, and she's told me as well, sometimes in her dreams, at least since she began the work that culminated in the Uluru Statement from the Heart around 5 years ago. I also want to acknowledge the amazing guidance and support that I've received from Professor Adrian Stone and Professor Emerita Cheryl Saunders, who with Megan supervised my PhD on Indigenous constitutional recognition. What role should a settler Australian like me, and I imagine many people in this audience, have in the pursuit of justice for First Nations peoples? In a society where Indigenous voices have long been ignored, suppressed or drowned out, many of us recognise that it's vitally important for non-Indigenous people to step back and make space for the voices of Aboriginal and Torres Strait Islander people. In my own field of legal education, it remains a struggle in many places for First Nations knowledges, experiences and perspectives to gain a hearing, including in UQ's own law school. The law school hasn't hired an Indigenous scholar in its 90-year history. And that's a situation I know that many of us in the school, including the current Dean, Professor Rick Bigwood, are working hard to rectify. There are also urgent conversations that we need to be having in the law school, and I know many of us are having those conversations already, about the presence of First Nations histories, perspectives and knowledges in the law school curriculum. All of these initiatives tie into the broader work being done by amazing people like Professor Bronwyn Fredericks, Professor Tracy Bunda, Associate Professor Sandra Phillips and many others to make UQ a more hospitable place for Indigenous experiences and understandings of the world. It's within Australia's political and legal institutions, though, that the voicelessness of First Nations peoples has had the most dire consequences. That's a situation which the Uluru Statements demand for a constitutionally enshrined First Nations voice to Parliament so rightly seeks to overcome. Given the ongoing voicelessness of Aboriginal and Torres Strait Islander peoples throughout so many arenas of Australian society, there's a serious risk that the well-intentioned involvement of settler Australians like me simply perpetuates long-standing dynamics of colonial domination and Indigenous marginalisation. But one constructive thing that non-Indigenous people, and I would say especially the lawyers among us, can and I think must do as allies in struggles for Indigenous struggles for justice is to take responsibility for our own law. That means taking responsibility for understanding and challenging the role of settler law in supporting and legitimating colonialism in the past and present. Taking responsibility for our own law also means using what power we have to support Indigenous struggles aimed at transforming that law in less oppressive and more emancipatory directions. Amid a federal election, the most urgent action we can take in that direction right now is to press as hard as we can on the people seeking our votes to accept the invitation in the Uluru Statement from the Heart. We need to push for a referendum in the next term of Parliament to constitutionally enshrine a First Nations voice. For settler Australians to take up the Uluru Statement's demand for a voice, followed by treaty and truth, is, in my view, to take responsibility for our own law. And to that end, I'd urge everyone to go to ulurustatement.org, if you haven't already, to find out how you can help and get involved. In a much smaller way, I've also tried to direct a lot of my own research and teaching towards the same end, taking responsibility for my own law's complicity in Indigenous oppression and for realising its potential to help undo that oppression. And it's to that end that I'm devoting this lecture today. For those of us committed to creating a more just relationship between Aboriginal and Torres Strait Islander peoples in the Australian state, we're familiar with a certain kind of argument made against Indigenous rights. This is an argument that asserts a fundamental incompatibility between the claims of Indigenous peoples for land, sovereignty and culture on the one hand, and Australian political traditions on the other. The argument, it has to be said, is mainly the province of those on the conservative side of the political spectrum. The most common variant asserts that recognising distinct Indigenous rights conflicts with a liberal ideal of equality that runs deep within Australian political culture. On this account, to recognise Indigenous rights is to afford Aboriginal and Torres Strait Islander people special privileges based on their racial ancestry and to thereby discriminate against non-Indigenous people. A second variant of the argument opposes Indigenous claims to sovereignty and self-determination on the basis that they conflict with the unitary, indivisible sovereignty of the Australian state. Australia's long-standing institutional arrangements cannot countenance a vision of sovereignty that's divided, shared, or multiple, or so the argument goes. So in this lecture, I'm going to suggest that one productive way of countering these kinds of arguments is, in a sense, to fight fire with fire. To those who assert a fundamental incompatibility between Indigenous rights and Australian political traditions, we can respond by appealing to aspects of those traditions themselves. My claim is that in the multitude of principles, rules, practices, and institutions that constitute the past and present of Australian law and politics, we can find resources for advancing First Nations struggles. Now, the point here is not to redeem Australian law and politics from their ignominious past. We mustn't forget that the colonial domination of First Nations peoples has, from the time of invasion, been at least partly constituted and maintained by the political and legal institutions of the Australian state and its colonial predecessors. That Australian political traditions can be deeply hostile to Indigenous rights is etched into the violent, oppressive and racist history of this country, and it continues to be reinscribed through the country's ongoing denial of First Nations demands today. Nor is my point that First Nations struggles for justice can simply leave the political and legal institutions of the Australian state as they are. Quite the contrary. In my view, to be adequate to the demands of Aboriginal and Torres Strait Islander peoples for land, sovereignty and culture, settler institutions must be radically transformed and substantial redistributions of political and economic power to First Nations peoples must be made. Instead, my point is that in political debates over Indigenous rights, we need not, indeed we should not, leave the task of defining Australian political traditions to the opponents of Indigenous rights, who selectively mobilise those traditions to their cause. Appeals to those traditions can have a powerful rhetorical effect among members of the Australian public, whose views, for better or worse, matter when it comes to the recognition of Indigenous rights by the settler state. How is it possible to draw on those traditions to support Indigenous struggles, given how fundamentally hostile they've been to the rights and interests of Aboriginal and Torres Strait Islander peoples? It's possible because, like all traditions, Australia's political traditions are full of ambiguities, tensions, and contradictions, conflicting values and competing principles. They always contain possibilities for contestation, redescription, creative appropriation, and adaptation. It's in attending to these possibilities within Australian political traditions that we can find resources for supporting Indigenous struggles for justice. I see the task of looking for these resources as part of the project I spoke about earlier, the project of settler Australians taking responsibility for our own law. In what follows, I'm going to point to two features of Australia's constitutional order, its approach to defining citizenship and its commitment to federalism, to show how Australian political traditions might be drawn on in the service of Indigenous struggles. Before I get to that, I'll start by fleshing out in a little more detail some of the ways that Australian political traditions are weaponised against Indigenous rights. Perhaps the most familiar way that Australian tradition is wielded to oppose Indigenous rights, as I said, is through appeals to Australia's liberal ideals of equality and non-discrimination. According to this argument, to recognise distinct Indigenous rights is to practice race-based forms of discrimination against non-Indigenous people. Appeals to Australia's liberal norms of equality and non-discrimination have been prominent in conservative opposition to the Uluru Statement and its demands for a constitutionally enshrined voice, treaty and truth-telling. Consider the Turnbull government's justification for rejecting a First Nations voice in October 2017. The government declared, and I quote, "Our democracy is built on the foundation of all Australian citizens having equal civic rights. A constitutionally enshrined additional representative assembly, which only Indigenous Australians could vote for or serve in, is inconsistent with this fundamental principle." Or consider the perspective of conservative think tank, the Institute for Public Affairs, which has set up a campaign and website opposing Indigenous constitutional recognition that's called Race Has No Place. In support of the supposed racial basis of Indigenous rights, these critics can and frequently do point to the fact that a person's entitlement to Indigenous rights depends partly on their descent. Take, for instance, the response by conservative commentator Andrew Bolt to the Uluru Statement's demand for a First Nations voice. If Australia agreed to this demand, Bolt said, and I quote, "We would forever be a racist nation where some Australians have more rights than others, not because they earned it or even need it, but simply because some of their long-dead ancestors were of the right race." So in other words, because an entitlement to distinct Indigenous rights is based partly on descent from the peoples who occupied the Australian continent prior to British colonisation, it's based on race, and therefore an invidious form of discrimination contrary to Australia's liberal heritage. A similar argument was taken up, albeit in less inflammatory terms, by the dissenting High Court judges in the 2020 decision of Love and Commonwealth. In that case, a majority of the High Court accepted the claims of two Aboriginal men that, despite them not being Australian citizens, their Aboriginality precluded them from being considered aliens under the Constitution, and therefore protected them from deportation. 3 judges dissented: Chief Justice Kiefel, Justice Gageler, and Justice Keane. Part of their reasoning was that because this entitlement to be a non-alien relied upon a person's descent from the Indigenous peoples who predated British colonisation, it amounted to a distinction based on race and so was illegitimate. Let me now turn to talk about another way in which Australian political tradition is invoked to oppose Indigenous rights. Here, the argument involves an appeal to a particular understanding of Australian sovereignty, one which sees that sovereignty as unitary and indivisible. That tradition of sovereignty, and in fact the very stability of the Australian state, is said to be imperilled by Indigenous rights, especially where they involve the recognition of First Nations collective autonomy. According to this argument, treaties are particularly threatening to the integrity of Australian sovereignty. When confronted with Indigenous demands for treaty on the day of the bridge walks for reconciliation in 2000, former Prime Minister John Howard famously responded that, and I quote, "A united, undivided nation does not make a treaty with itself." Similar arguments have been made in response to the demands formulated in the Uluru Statement. Perhaps the most insistent purveyor of this argument today is Conservative commentator and historian Keith Winshuttle, who has claimed that acceding to First Nations demands for constitutional reform and treaty would lead to, and I quote, "the breakup of Australia," which is the title of his 2016 book on the topic. A similar line of argument was taken up by the dissenting High Court judges in the 2020 Love case. They held that recognising First Nations collective autonomy over who counts as Indigenous, and consequently over who counts as an alien under the Constitution, would amount to recognising Indigenous sovereignty, or at least come very close to it. And to recognise Indigenous sovereignty, the dissenting judges said, would impermissibly contradict the unitary and indivisible vision of Anglo-Australian sovereignty upheld under Australian law. Okay, so let me return to the argument that Indigenous rights conflict with Australian liberal norms of equality since they involve racial discrimination against non-Indigenous people. That argument, as I said, perceives indigeneity as a racial category, principally because one of its central components is descent. From this perspective, to rely on descent is to invoke a biological account of an Indigenous race. And to confer distinct rights on the basis of Indigenous descent is to racially discriminate against non-Indigenous people. But those claiming that descent renders indigeneity a racial category overlook an inconvenient fact. That fact is the central role played by descent in creating and reproducing the Australian political community itself. And I want to acknowledge the work of Kirsty Gover at Melbourne Law School, who first drew my attention to this fact. Descent operates at the centre of Australia's constitutional order, helping to constitute the body politic through the domain of citizenship law. Instead of being posed as an irredeemably racial practice, the operation of descent in conferring Australian citizenship is taken for granted as a legitimate foundation for grounding the political community and for conferring distinct rights on members of that community. Here, I want to suggest, is one way in which Australian political traditions might be drawn on to support Indigenous rights. So let me outline just in a little more detail how dissent has operated in Australian citizenship law. Since Australian citizenship was first created as a formal legal category in 1948, Australian law has always enabled a person to acquire citizenship on the basis of descent. The critical element is for a person to be the child of an Australian citizen, or more recently, the child of a permanent resident. Under Australia's first citizenship law in 1948, a provision headed Citizenship by Descent conferred citizenship on people born outside Australia where they had an Australian citizen for a parent. According to current Australian law, the standard mode of acquiring citizenship automatically is a mix of birthplace and descent. Citizenship typically comes about from being born in Australia to one or more Australian citizens or permanent residents. People born outside Australia who have an Australian citizen as a parent can become citizens themselves by application, another manifestation of citizenship by descent. And these sorts of rules aren't uncommon, as I think we got a fairly graphic reminder of in the sort of the imbroglio under Section 44 of the Constitution and all these parliamentarians with foreign citizenship on the basis of their parents and where they were born. Which reflects the fact that using descent as a basis for the acquisition of citizenship is widely practiced worldwide. So how can these long-standing and taken for granted Australian practices for constituting the political community be useful in Indigenous struggles over land, culture and sovereignty? I want to suggest that they represent one way for supporters of those Indigenous struggles to counter critics who invoke liberal norms of equality against Indigenous rights. The workings of Australian citizenship law powerfully demonstrate how using descent as a basis for conferring rights need not be seen as relying on race. Rather than being irretrievably mired in biological ideas of an Indigenous race, descent can be conceptualised as a mechanism for constituting and sustaining Indigenous political communities, just as it sustains the broader Australian political community through the operation of citizenship law. The role of descent in Australian citizenship law and in citizenship regimes the world over provides a powerful rejoinder to those who would seek to oppose Indigenous rights as race-based discrimination. As Australian citizenship law has long confirmed, descent can be a relevant characteristic for differentiating between different groups of people and conferring different rights on them. So here then is one example of how we might respond to the invocation of Australian political traditions against Indigenous rights, by invoking other Australian political traditions that actually support the recognition of those rights. Let me now turn to the other argument from Australian political tradition that I mentioned, according to which Indigenous rights must be opposed because of the threat that they pose to the supposedly unitary, indivisible sovereignty of the Australian state. That argument is made especially against reforms that would recognise the collective political autonomy of Aboriginal and Torres Strait Islander peoples, and most particularly against treaties. The remarkable thing about assertions of the Australian state's unitary sovereignty is how blind they are to the historical and contemporary reality of Australia's constitutional arrangements. The inconvenient truth about those arrangements is that they are founded upon, indeed they celebrate, the fracturing of sovereignty. I'm talking, of course, about federalism. Federalism is arguably the lodestar of Australia's constitutional system and a central part of Australia's political traditions. Broadly speaking, federalism involves combining two things. First, self-rule for distinct political communities, and second, shared rule through an overarching association of those distinct communities. Put in these terms, Australia's states and self-governing territories are distinct political communities who enjoy forms of self-rule, while also participating in the shared rule practiced by Australia's national institutions. Given that the charge of undermining the Australian state's apparently indivisible sovereignty has been levelled most frequently at First Nations' demand for treaty, it's worth noting that the idea of treaty is actually foundational to federalism. The etymological roots of federalism are to be found in the Latin word fedus, meaning, I don't know if you guessed it, treaty. Contrary to John Howard's claim then, Australia has already made a treaty with itself. It's called the Australian Constitution. Treaty making is precisely the task undertaken in the 1890s by the 6 Australian colonies in constructing a constitution for a new federal nation. In its federal character, the Australian Constitution is a treaty between different political communities who agreed to unite in a single overarching association while maintaining their own autonomy and distinctness. It's striking, and I think not a little jarring, that the most strident opponents of collective Indigenous autonomy, those on the conservative side of politics, have also traditionally been the most ardent admirers of federalism. In ideological inclination, if not always in governmental practice, Australian conservatives have conventionally been attracted to federalism as a form of government that's divided and therefore limited, that's closer to the people at the local level, and that respects pre-existing political communities. From the picture of Australian federalism that I've painted, it should now be fairly clear how this dimension of Australia's political traditions can be useful in First Nations struggles for sovereignty. To those who say that Indigenous demands for self-rule are a threat to the unitary sovereignty of the settler state, we should respond that Australia's constitutional system is founded upon a fracturing of sovereignty in which multiple political communities are constitutionally recognised. Why should our support for the federal principle not extend to political communities that are millennia older than those presently recognised within Australia's federation? First Nations claims for collective autonomy can be understood as fundamentally federal in character, combining demands for self-rule with demands for fuller and fairer participation in the shared rule of Australia as a whole. Take again the demands made in the Uluru Statement for a constitutionally enshrined voice to Parliament and the negotiation of treaties. A First Nations voice would provide Indigenous peoples a greater say in the shared rule that governs Australia nationally. As for treaties, these might likewise set out the terms of shared rule between First Nations and the Australian state, such as high-level principles governing their relationship, while also recognising forms of jurisdiction to advance self-rule for First Nations on the local level. Recognising First Nations' collective autonomy in these ways would be politically and constitutionally transformative. But it wouldn't undermine some imagined unitary sovereignty of the settler state, for the simple reason that that sovereignty has long been divided and shared among discrete and multiple political communities. Far from being in conflict with Australian political traditions, meeting First Nations demands for the recognition of their sovereignty would be fundamentally consistent with Australia's history of federalism. So let me say a few things by way of conclusion. When it comes to the relationship between First Nations and the Australian state, many non-Indigenous people, as I've said, rightly feel the need to step back and make space for Indigenous voices. Having a voice that's listened to, possessing collective power over the social, economic, and political conditions of existence. These are long-standing demands of Aboriginal and Torres Strait Islander peoples, articulated so powerfully in the Uluru Statement. But while recognising these demands does indeed require settler Australians to step back and make space in some ways, these aren't passive acts. They're definitely not the same as being silent. The Uluru Statement's call for voice, treaty and truth won't be realised by non-Indigenous people being silent. Silence simply allows the status quo of settler domination and Indigenous disempowerment to reproduce itself. Voice, treaty and truth can only be realised if non-Indigenous Australians are willing to actively take responsibility for our own law. One way that we can discharge that responsibility, I've tried to suggest, is to rethink our own political and legal traditions. An essential part of that rethinking involves having our eyes wide open to the complicity of those traditions in the dispossession and oppression of First Nations peoples, and being alert to the ongoing weaponisation of those traditions against Indigenous rights today. But another imperative, I think, is to be alive to the ways that those traditions can provide resources for supporting Indigenous struggles for justice. Quentin Skinner has written that all revolutionaries are obliged to march backwards into battle. What he means is that those seeking transformative political change must, to some extent, appropriate existing languages and traditions to legitimise their projects and make them intelligible. The point is that instead of simply being obstacles to political change, or worse, the cause of injustice themselves, existing traditions can, in all their diversity, malleability and contradiction, provide resources which can be marshalled to the cause of political transformation. As I've argued in this lecture, Australia's laws on citizenship and its federal tradition provide resources that are ripe for appropriation in support of the transformative change envisaged in the Uluru Statement and in other campaigns for Indigenous rights. These are some of the intellectual resources we can draw on as we seek to discharge our greater responsibility, unsettling settler law in the name of a just political relationship between First Nations and the Australian state. Thanks.
Thank you very much, Dylan, for making such a powerful and eloquent case for the need to re-examine our political traditions and for non-Indigenous Australians in particular to take responsibility for the legal system that we have. And thank you to all of you for coming along, and please come along to other events in this series. Thank you very much for coming and have a very good afternoon.